The Honorable Court of Appeals of Tennessee is now in session.
Before we call the case, mention one thing to council that if we should have any technology related problems, everybody just take a deep breath and we'll take a pause, and our Ms. Kraft and our AOC IT folks will get it back on going quickly. I have great confidence, so don't anticipate any problems. So call the case, please.
Adam Garabrant versus Jeffrey Chambers et al.
We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
May it please the court. My name is Russell Morgan on behalf of Adam Garabrant. I have with me in this room today Brian Epling, my colleague. It's nice to see you all virtually. Your Honors, the trial court's judgment and order in this case should be reversed for two reasons. First, the trial court did not properly apply Tennessee Code annotated 67-2-2504, which provided Mr. Garabrant and his predecessors an interest in his chain of title and an assurance of perfect title under a tax deed, and also provides that no such conveyance shall be invalidated in any court. Secondly, and the trial court erred in its application of 28-2-109 because the undisputed evidence established that Mr. Garabrant and his predecessors in interest paid property taxes on tax map 11 parcel 14 for 20 years or more. This case, so I'm going to start by saying that we're referencing tax map 11 parcel 14 in Scott County. For the ease of conversation, I'm just going to refer to it as parcel 14. This case implicates a very significant interest in Tennessee tax deeds and the commerce of those tax deeds, because the court has essentially found that a tax deed and the conveyance under a tax deed was null and void. The two principles in this case, three principles really apply in this case that dictate the result. First off, as indicated, 67-5-2504 and the doctrine under that statute under Schaefer versus Mitchell, in which a very similar circumstance occurred, and there was a long period of conveyances of tax deeds. And in that court, in that case, the court said every reasonable presumption should be indulged to uphold such a conveyance unless it's void on its face. So by way of, and the third issue is related to the 20-year statute of limitations. By way of background, in the early 1970s, Scott County assessors started to establish tax maps within the county. At that point in time, parcel 14 was established and placed on the map. Its northern boundary was contiguous to the Kentucky-Tennessee state line. The taxes were assessed on that property to G.W. King, and for a number of years, those taxes were not paid. So in 1979, the trustee of Scott County instituted a lawsuit to collect the taxes. That ultimately resulted in an order of sale. The order of sale is Exhibit 14, and the order of sale contained a property description, but it also contained a clear indication that it was applicable to parcel 14. It said on the order of sale, tax map 14 parcel, or tax map 11 parcel 14. The clerk and master proceeded with the order of sale and sold the property and issued a clerk and master's tax deed. And the description on the clerk and master tax deed in 1981 was map 11 parcel 14. That was the only description. This particular piece of property, parcel 14, changed hands a number of times, and in 2006 was acquired by my client, Adam Garabrant. Mr. Garabrant paid taxes, and the undisputed evidence is the taxes were paid on parcel 14 from 1941 going forward, even until today. Mr. Garabrant actually paid taxes on it this year. In 2016, Mr. Garabrant noticed that there was some clearing of the timber on that piece of property. As a result of that, Mr. Garabrant commissioned a survey to establish the eastern boundary of the property. The northern boundary, which was the Kentucky state line, was easily discernible. The western boundary and the southern boundary were already established by a prior survey by TKY, so those were easily discernible. The only thing that needed to be done was the eastern boundary. So EarTech went out and marked the eastern boundary using the northwest corner of the TKY property as the boundary marker. Mr. Garabrant initiated a lawsuit against the trespassers, who happened to be the adjoining property owners of 12 and 13. That was McCreary County Lumber, who's an intervening defendant in this case. McCreary owned the property and then subsequently conveyed it to a Charles Stevens. Charles Stevens, after the lawsuit was filed, ended up conveying the property to the Chambers. Mr. Stevens testified at trial, well, by deposition, that he was aware that he did not own parcel 14, that he owned parcel 12 and 13. He also was aware that he did not sell parcel 14. He sold parcel 12 and 13. The Chambers were aware of this lawsuit when they bought it, and they understood that they were purchasing parcel 12 and 13. The Chambers undertook to have a survey done of the property, and the survey that they had performed completely disregarded parcel 14 altogether. The survey was recorded in the land records, and that created this dispute of title. Mr. Garabrant filed the complaint to have a declaratory judgment. After a 2-day trial, the trial court essentially ruled that Mr. Garabrant owns nothing. After 40 years, after this deed has been in place for 40 years, and after the tax map has been in place, she basically issued a ruling that said parcel 14 does not exist for all purposes on the land records of Scott County. The trial court's decision should be reversed for 2 reasons. First, the trial court erred in disregarding the perfect title Garabrant received through the tax deed. As indicated, the Schaefer case clearly says that when a tax deed has been in commerce, in that case it was 35 years, in this case it's 40 years, for such a long period of time, every reasonable presumption should be indulged to uphold that conveyance unless it's void on its face. Here, there's no question that the tax deed was not void on its face. It's not been challenged as void on its face.
Mr. Morgan, I'm sorry for interrupting, but ultimately, doesn't this case kind of hinge on which expert the trial court found to be more credible in terms of determining the boundary lines of the property? Because of course your expert says it's parcel 14 and their expert says it's not. It's a completely different tract within another tract that's not really part of the properties at issue in this case. And I know you're saying, well, no, because that's not what was conveyed to us in the tax sale, but the tax sale description does not, can't be used to provide boundaries, correct?
Oh, I believe that, yes, the surveyors identified. So let me address your point.
Okay.
Their surveyors, first off, their surveyors purported to go back to the land grant. And there were a lot of problems with that testimony. First off, the land grant purported to convey 50 acres, 30 of which was in Kentucky. But here, there would have only been 20 acres left over, but the Chambers are claiming they have 50 acres, so the math doesn't add up. Their surveyors also acknowledged that none of the land grant markers that were in the land grant were on the ground. They couldn't find them. So they tried to claim that they went to the land grant, but they have no proof other than their own testimony that they went there. But more importantly, the assessor identified, so to get to your point, the assessor identified that the taxes on the property are assessed to the dirt within the boundaries. And as a result of that, the dirt within the boundaries, the land doesn't really move. The dirt within the boundaries is the dirt within the boundaries. As the surveys go along, those lines may be more corrected on the tax maps, but the dirt's always the dirt right where it belongs. They never found any evidence to dispute that. They just ignored altogether the tax deed. Now I want to address the tax deed. The order of sale identifies a description, but it also identifies map 14, parcel 14. To give every reasonable presumption to that deed, you have to give the benefit of the doubt that what was sold was the dirt on the ground at the location of the tax map. And as a result, their surveyors made a mistake because they were testifying as to ownership. They were not testifying as to the boundary. The boundary is the eastern boundary that Mr. Phillips and Eartec found. So they cannot testify as to ownership. That's not within their purview. Under the law, the tax deed conveyed clear, perfect title. And they can't ignore that clear, perfect title, even though it was described as a parcel. And here, because the judge did not give any weight to the tax map parcel number, she did not give every reasonable presumption as required under the Schaefer case to the tax deed. And she effectively ignored the tax deed altogether, which is in violation of 67-2-105.
Counsel, Counsel, I'm sorry, help me here. I'm easily confused with property disputes, but the property description from the tax sale and the tax sale deed, did it include the dirt that was parcel 14?
It identified it as parcel 14. It did not identify a meets and bounds description.
The tax sale, the deed didn't have a meets and bounds description.
It did not.
All it said was the deed said parcel 14 on the tax sale.
That's all it said.
Okay.
And under the Schaefer case, you can't go beyond that if you're going to give validity to every reasonable presumption. But even if you do go beyond it, you still can't ignore that there's two aspects of the order of sale, and the judge.
Well, what did your client's surveyor survey then?
The client survey so there was on the southeast corner, there was a mark from the TKY survey, and on the northeast corner, there was a prior mark from a prior TKY survey. And so he connected those 2 points together to get the eastern boundary, which is logical and it's consistent with the tax map, and it's consistent with the location of parcel 14 on the tax map. The trial court also erred in failing to properly apply 28-2-109 because it's undisputed that Mr. Garabrant and his predecessors paid taxes on this property for 30 years, and that the chambers and its predecessors never paid taxes on parcel 14. They paid taxes on parcel 13. So the trial court should have given a rebuttal presumption. I'll address in rebuttal why the defendants did not properly rebut that presumption.
All right, thank you, counsel. You have your time for rebuttal. We're here from the appellees, and we understand that counsel, y'all have divided your time. So is that correct?
That is correct, Your Honor.
How much are you taking, counsel?
10 minutes, Your Honor.
Okay, if we could, let's put 10 minutes up on the clock. Thank you.
May it please the court, Steve Markham from the Huntsville, Tennessee bar. I guess what's missing here is some of the background that is essential to understanding what is happening with this case. The deed reference, map 11 parcel 14, follows a decree of sale. The decree of sale had a more specific description. It had a bounds description in it. And then typewritten, of course. And then on the decree of sale, there is a handwritten notation, tax map 11, parcel 14. There is no proof in the record to establish who made that handwritten addition, when it was made, or whether or not it was ever authorized by the court. There is not one line of proof that addresses that issue. So the deed then follows a couple of years after the decree of sale. The decree of sale was in 1981. The deed was delivered in 1983. And the deed says tax map 11, parcel 14, and that's it. But it does refer to the G.W. King estate. Well, what's really interesting about this and what makes this case different from any that we have seen is the fact that the property described in the decree of sale is nowhere near the area in dispute. And that is agreed to not just by the Chamber's two surveyors, Mr. Reed and Mr. Boyd, but also by Mr. Garabrant's surveyor, Mr. Phillips. Mr. Phillips conceded that the property described in the decree of sale is over 8,000 feet away from the area in dispute. Now, Mr. Phillips, Mr. Garabrant's surveyor, took a couple of runs at establishing, preparing a map that related to this issue. The first time around, he basically admitted he was trying to survey a tax map. He had no description to work from. He chose not to even look at the decree of sale. He never looked at the decree of sale before he did his work. And he testified that in his opinion, it would have been surveying error to go back beyond the deed to see what the decree of sale said. And he also said it would be surveying error to look at prior deeds in the chain of title, which completely flies in the face of the statute that we cited that relates to surveyors, which requires surveyors to look at the land records in order to do their homework and be prepared to do a good job. So Mr. Phillips, in his first effort, said that the property that he laid out, the boundary that he laid out, defined the boundary between the estate of G.W. King and the Chambers. And he said that tax map 11 parcel 14, as located by him, was the property of the G.W. King estate. But he took yet another run at a map, and he concluded the next time around that map 11 parcel 14 wasn't related to the G.W. King estate at all. He concluded that it was actually property of a William King, that despite the fact that he never could find a deed to that property from William King or to William King, but he still concluded that was the William King property and that the public records references to the G.W. King estate were wrong. And you can see that in the notes on his survey that was admitted into evidence. It's included at page 10 of Appendix 2 that we submitted to the court, where he says that the property in dispute was the property of William King. So now we have a situation where their surveyor has admitted that the property described in the decree of sale is not in the area of dispute. And he's now also admitted that the area in dispute was not even the property of G.W. King. So we essentially have an orphan tract. Mr. Phillips tried to survey map 11 parcel 14. He admitted that that's what he was trying to do. Whose property was it? He says it was William King's. Well, that doesn't fit the decree. Now, the other thing that we all need to know is that when he came up with his survey, he was surveying the current version of the tax map, but that was not the version of the tax map that existed as of the time that the tax sale occurred. And the orientation of the tax map on the public records changed between 2009 and 2010. And at page 12 of Appendix 3, we have a copy of the diagram showing the change in location. So although they say they paid taxes on a particular area defined by the tax map, even that changed, and they didn't pay taxes on that for 20 years. The testimony of Surveyor Reed was that the configuration changed significantly on the tax maps, as well as the parcel was moved about 1,000 feet. The other things that the court needs to bear in mind is that the Chamber's title, according to surveyors Reed and Boyd, and they are tasked with examining the records, and they did examine the title records and concluded that the Chamber's title did go back to the original 1843 grant from the state of Kentucky. Did they find the original markers referenced in that grant? No, they didn't, because they don't last that long, but they found boundaries of adjoining owners consistent with the cause of the original grant. Did the math work out exactly as referenced by counsel? Well, no, but it's common knowledge and recognized in the cases that the older descriptions of real estate were often famously inaccurate, and the assessments of acreage often were not precise. Without question, they were not precise, and that's referenced in Tennessee case law. So we know that the Chamber's title goes back to the Kentucky grant. We know, according to the survey of Mr. Boyd, he was out on the property 15 to 20 times over a period of 6 weeks, surveyed the entire boundary of the property. Mr. Phillips, the Garabrant surveyor, was on the property once for half a day, and he located one point, which was a point established for another survey for another client, and that's all that he ever did on the ground. Mr. Boyd's conclusion was that the area claimed by plaintiffs is completely encompassed by the boundaries of the Chambers property. What that means is when we go to application of the tax statute and the presumptions, the Chambers and their predecessors, according to the proof, paid taxes on their parcel for more than 20 years. They paid taxes on the area that encompasses the land in dispute. So although Mr. Garabrant has established that he paid taxes on the assessment, map 11, parcel 14 for 20 years, that leaves the parties basically in equal position, but not completely equal, because the fact of the matter is, map 11, parcel 14, by the admission of his own surveyor, was not the property of the G.W. King estate, which is what was sold at the tax sale many years ago. I think for the court in this case to rule in the favor of Mr. Garabrant, it basically has to conclude that the parcel claimed by plaintiff, although it no longer relates to the G.W. King estate, according to their surveyor, somehow takes precedence over the Chambers title that goes all the way back to the Kentucky grant, and for which taxes were paid for a period of more than 20 years before this dispute began. I don't think there is any case law or any statute that would validate that kind of action. This is just an odd case by any means, but the property that was sold by the Chancery Court was 1.5 miles away from the area that is in dispute. Thank you.
Thank you, counsel. We'll hear from you, Ms. Madden.
Yes, good morning. I seem to be getting some feedback here. Just a second. Okay, let's see if that's better. As you know, I represent McCreary Hardwood in this case, and we are the predecessor in title to the Chambers, and intervened in this case because our position aligns directly with the Chambers and what Mr. Markham has said this morning. I would just like to add a couple of points. And in regard to the adverse possession claim, the record is clear, and Mr. Markham has addressed the payment of taxes, so I won't touch on that again. But in order to prevail on that theory, the plaintiff would have to prove and establish the required elements of adverse possession. And the plaintiff was unable to do that under any theory of adverse possession in this case. Those elements being possession was actual and exclusive, open, viable, and notorious, continuous and peaceable, and hostile and adverse. The proof in this case, and the record is clear, that the plaintiff purchased the property from a website for $5,000. He made no improvements to the property, built no structures on the property, did not mark the boundaries, placed no signs or fencing, and did not survey the property, and did not farm the property, log it, or use it otherwise. The plaintiff testified that there were years when he didn't visit the property at all. And the chancellor's ruling that the plaintiff's proof failed to establish any elements under this theory should stand in this case. There's no reason, no factual proof to reach a different conclusion in that regard. And just to follow what Mr. Markham, in regard to the tax sale issue, the if we follow the plaintiff's argument in this case, what in effect would happen is that this tax sale deed, using only a map and parcel number, would, to give it the effect the plaintiff claims, would in effect eject property owners who have held continuous title of this property back to the land grant. And that certainly would not be a wise outcome in comparing the interest of these two parties. And for these reasons, and for the reasons stated by co-counsel Mr. Markham, the Chancery Court ruling should stay.
Thank you, counsel. We'll hear from the appellant rebuttal.
Yes, Your Honors. I want to first address Ms. Mann's argument with respect to adverse possession. As the court knows, we are arguing under Section 109 that Mr. Garabrant is entitled to title as a result of paying taxes for more than 20 years, he and his predecessors. So let me start out in the big picture. Since 1970, on the land records of Scott County has existed tax map 11 parcel 14. It's exhibit 15 in the court record. That's existed for 50 years. And then 50 years later, there's now a challenge by by somebody who's now got title, who even knew that this lawsuit was occurring after they got title. So what happens, and I mean, that's the reason we have these adverse possession statutes, is to give some security in ownership. How many people are going to come out of the woodworks 50 years later and start challenging title to their neighbors? So that's a major issue. Under 109, there's two elements: color of title. Mr. Garabrant has color of title. In fact, he's got a perfect assurance of title under 67-2-4205. Perfect assurance of title. Second, that he paid taxes for 20 years. That was established by the assessor and the trustee at trial. Both of them said that Mr. Garabrant and his predecessors paid taxes on the dirt under that piece of property. So I think that addresses that. Now, Mr. Garabrant's entitled to a rebuttable presumption, and I want to address the comments from opposing counsel as it relates to that. Opposing counsel basically admitted exactly what we're saying. There's not sufficient proof. There will never be sufficient proof in this world that allows them to rebut the presumption, because there's not sufficient markers for the land grant. Even they admitted that their own deeds don't provide a description that allows them to do a survey. So basically, you had a couple of surveyors that went out there and made up information in order to reach the conclusion. Mr. Boyette used the exact same markers that SpearTech used to do the survey for Mr. Mr. Garabrant. It's the SpearTech survey, or it's the TKY survey that surveyed the western and the southern borders. So he didn't do anything new. Him going out there a bunch of times, he didn't add any value. The only thing that had to be determined is the eastern boundary. Now, I think the other point that I want to make out, going back to opposing counsel's argument, he said that it was improper to look at, it was improper for SpearTech not to look at the prior deeds. It violated the law for anybody to look beyond that. As I indicated earlier, Schaefer versus Mitchell, which is a Supreme Court case that has never been overturned, it says, after a long lapse of title, especially when the original proprietors have asserted no title, we think every reasonable presumption should be indulged to uphold such a conveyance. That's what we're asking the court to do here. Tax map 11 parcel 14 was the parcel that was on that deed. And that was also the parcel that was written on the order of sale. There's no reason in the record, if you're going to indulge every presumption, you have to support Mr. Garabrant's title on this, because that's what Tennessee law requires, and the court erred in not doing so. There's also not insufficient evidence to rebut the presumption under section 109 that Mr. Garabrant's entitled to. So for these reasons, Mr. Garabrant respectfully requests that the court reverse the trial court and enter a order declaring him owner of parcel 14 at the location on the tax map and enter ear text survey for the boundary description. Thank you, Your Honors.
Of course, thanks to all counsel. We appreciate your oral arguments and your briefs on this matter. If you would, please recess court till our next scheduled case.
This Honorable Court of Appeals